पूरा सुनवाई करके जो आज ऑर्डर पास किया है, मैं इसका स्वागत करता हूं। सुप्रीम कोर्ट का जो बेंच ने जो तय किया है, ये हमारा लोकतंत्र के लिए भी बहुत अच्छा शुभ संकेत है।
The Waqf Amendment Bill was challenged in court. The Supreme Court has now made its observation on the petitions that were filed challenging the amendment made to the Waqf Bill. And now, as it turns out, several provisions that were created as part of the amendment have been put on hold. The earlier hearing was on the 22nd of May when the court reserved its order. Today, on the 15th of September, the court has passed an order staying or putting on hold certain provisions. The final order is still awaited. A detailed judgment, so to speak, is still awaited. Hi, you're watching Free Press Journal. I'm Afrida Rahman Ali. Do like, share, and subscribe to Free Press Journal for quality content on news events. And don't forget to press the bell notification to get alerted. So let's get started by giving you a detailed report on what are the provisions that the Supreme Court has ticked off as the ones to be put on hold. It has played a very interesting role as a balancing power, not letting the administrative powers become overriding over a religious institution, and yet putting certain checks and balances in order to ensure that the Waqf board members do not misuse powers. Let's get started. On the 15th of September, the Supreme Court stayed key provisions of the Waqf Amendment Act 2025 in an interim order. This includes the contentious 5-year religious qualification to create a Waqf and the provision allowing government officers to adjudicate property disputes. The order was passed by a bench of Chief Justice of India B.R. Gavai and Justice A.G. Masi. Let's listen in to Advocate M.R. Shamsad on the Supreme Court's order.
See, we consider that today's order on Waqf Amendment Act is reasonably good. All the issues except one issue which relate to Waqf by user, all the issues have been addressed by the Honorable Supreme Court, and most of them have been stayed. Number one, that the requirement of somebody being practicing Muslim of 5 years, that has been stayed. The Waqf Council's composition, where the number of non-Muslim members were vague, that has been limited to 4. Similarly, Waqf Board has been limited to 3. As far as collector's power is concerned, that during the pendency of the dispute so created by the government, the collector will record entry in the revenue record saying that this is not Waqf property till the time it is decided by the appropriate authorities or judicial forum. The court has said that this violates the doctrine of separation of power. So that has been specifically stated and said that no revenue record shall be altered, and till the time final decision is taken, no third-party right shall be created.
The court stayed Section 3(1)(r) of the amended act, which mandated that the person must be a practitioner of Islam for 5 years before creating a Waqf. The bench held that this condition cannot be enforced until state governments frame rules for determining who qualifies as a practitioner of Islam. Point number 2, the court stayed the provision that allowed designated government officers to decide whether a Waqf property had encroached on government land. It held that permitting executive officers to adjudicate such matters violate the principle of separation of powers. However, it clarified that no third-party rights may be created until the matter is decided by the tribunal. Let's listen in to Advocate Varun Sinha speaking on the Supreme Court's order in the Waqf Amendment Act.
You see, the Honorable Supreme Court has made very categorical interim order today. Number one, there is no stay on the amendments brought in by the central government headed by Maniya Narendra Modi ji. So there is no stay on the amendments.
Point number 3, while the court did not stay the provision allowing non-Muslim members of Waqf boards, it observed that as far as possible, ex officio members should be Muslims. According to a report by Live Law, the Central Waqf Council can have not more than 4 non-Muslim members that may be appointed, and for the state boards, the upper limit is 3. Point number 5, the court also upheld the registration requirement for waqfs, saying that it was not a new condition and already existed under the 1995 and 2013 enactments. However, the deadline for registration has been extended with the timeline to be specified in a detailed judgment. The bench had reserved its order earlier on the 22nd of May after hearing arguments across 3 days. The petitions filed by political leaders, civil rights groups and religious organizations challenged several provisions of the 2025 amendments on constitutional grounds. Intervention applications in support of the law were filed by BJP-led states including Assam, Rajasthan and Maharashtra. Reacting to the court's interim order on the Amendment Act, Syed Qasim Rasool Ilyas, member of the All India Muslim Personal Law Board, said that many of their concerns have been addressed. Let's listen in.
बड़ी हद तक हमारी बात मान ली गई है। देखिए, वक्फ बाय यूज़र पे हमारी बात मान ली गई है। इसके साथ साथ जो है प्रोटेक्टेड मॉन्यूमेंट के ऊपर भी हमारी बात मान ली गई है कि कोई थर्ड पार्टी क्लेम नहीं होगा, ये बात मान ली गई है। 5 साल की जो कैद लगाई गई थी वो हटा दी गई है और इसके साथ साथ जो है उम्मीद पोर्टल को डेट को एक्सटेंड करने की बात कही गई है।
The court has also clarified that the CEO must be from a Muslim community and the overriding powers given to the district collector for deciding whether a property is a waqf or not have also been stayed. The stay on sections 3 and 4 has been welcomed by members of the Muslim Personal Law Board. To my mind, the most important part of this order is where it puts on hold the sweeping powers that were given to a district collector to adjudicate on a matter whether a property was waqf or not, whether there was encroachment into government property or not. So here the court feels that that is actually executive stepping into the territory of judiciary. So that provision has clearly not been approved by the Supreme Court, and that was one of the most contentious issues, that how can a district collector be given the task of adjudicating in this manner. It would have literally created a lot of chaos and conflict and only made matters worse in the overall scheme of things, because if every single property the district collector has to now decide on its authenticity or on its suitability, whether it qualifies to be called a waqf property, then clearly that would lead to serious amount of complications. We know the district collector, of course, is lower down in the hierarchy of things. So it is actually government control. It is actually the government who would have the final word in it, which I think the Supreme Court sort of perceived as something which is not constitutional, and therefore it said that there has to be the separation of powers which has to be stringently maintained. Thanks for watching. Do write in to us with your comments on what you think on this issue. Subscribe to Free Press Journal and share this content if you found it useful.